Let's take a look at a key case within the law of tort. This is the case of Calvert v. William Hill, 2009, and this is a negligence case which concerned the issue of causation. In this case, the claimant was Mr. Calvert, who was making a claim against William Hill Credit Limited, the bookmakers. The claimant was a pathological and addictive gambler who had excessive gambling habits. Following excessive telephone gambling with William Hill, he asked that his account be closed and not reopened as part of the self-exclusion procedures that William Hill offered. His account unfortunately was not closed properly, and William Hill allowed him to continue gambling, and he lost in excess of £2 million in the 6 months after he asked to be self-excluded. He sought this money in damages from the defendants upon the basis that they breached their duty of care to him to allow him to continue gambling, and therefore they owed him the amounts that he had lost when he was allowed to gamble. The outcome of this case at trial was that the defendant was not liable, and the trial focused upon the but-for test. The judge felt at the trial that the defendants were not liable because of the nature of the claimant's addictive gambling meant that had they imposed the self-exclusion properly, he would still have lost that money anyway, but for their breach, he would still have continued to gamble with other bookmakers. This was not in fact the justification which was reviewed at appeal, where instead the judge sought to focus upon the scope of the duty and said that the defendant bookmakers did not owe him a duty of care to prevent him from gambling absolutely. They did not assume responsibility for all of his gambling, but rather it was the scope of their duty was to help him control it. The outcome of the case was that the defendants were not liable for the defendant's losses associated with his gambling.